Student loans are back in the news. Oh boy, specifically the SAVE repayment plan and some court decisions. Welcome to the College Investor Audio Show. Before we get to some court decisions that were being made just recently, I just want to remind you, anytime we talk about any topic on the podcast, you can always see the article associated with it at thecollegeinvestor.com. Also, follow us, like us, and all the things on social media. We're pretty much anywhere you are. We'd love to get to know you and help you along in your journey. Just search for The College Investor, and you'll find us. All right, so here are some court decisions, kind of like the final blow to end the SAVE student loan repayment plan. Here we go. It's been a long-running legal battle over the Biden administration's Saving on a Valuable Education, or SAVE, plan reached a conclusion on Tuesday when the U.S. Department of Education and the state of Missouri announced a proposed joint settlement agreement. You can see that agreement, PDF file, in all of its glory at thecollegeinvestor.com that would essentially terminate the program pending final court approval. The announcement, which we've been pretty much expecting for months, especially in light of the One Big Beautiful Bill Act, also terminating the plan, brings borrowers another step closer to some timelines for resuming their payments. The agreement, filed in federal district court, comes after nearly 2 years of legal challenges from Missouri and several other states, which argued that the administration exceeded its authority by redesigning the federal income-driven repayment system through executive action. Courts repeatedly halted portions of SAVE and earlier this year blocked the program in its entirety, throwing borrowers into a prolonged period of confusion. Under the proposed settlement, the Department of Education will stop enrolling new borrowers in SAVE, deny all pending applications, shift existing enrollees into other legally authorized repayment plans. And the department would also actually undertake a negotiated rulemaking process to formally repeal SAVE and address related regulatory questions, such as how, when, and where the borrowers in SAVE are actually going to be moved. The settlement still requires judicial approval, but that's really not going to take long. It's important to note that the negotiated rulemaking process will determine how and when SAVE is formally removed from federal regulations. Okay, now, here's how the SAVE plan trapped millions of borrowers. It was created in 2023 by amending the existing repay program. SAVE promised lower monthly payments and a shorter path to forgiveness for certain low-balance borrowers. The Biden administration also reduced the share of discretionary income used to calculate payments and increased unpaid interest protections. But state officials argued that the changes amounted to an unauthorized rewrite of federal law and would impose significant costs on taxpayers. The state's lawsuit challenged the 2023 rule that established SAVE and its underlying forgiveness structure. On multiple occasions, courts tended to side with the states. In July 2024, a federal district court blocked parts of the plan, prompting the administration to place all SAVE borrowers into a 0% interest administrative forbearance. So earlier this year, the Eighth Circuit Court of Appeals halted the rest, but ending the interest freeze and sending the case back to the district court. By midsummer 2025, federal officials notified more than 7.6 million borrowers that interest would begin accruing on August 1st and encouraged them to consider switching to other repayment plans. The proposed settlement would close the case entirely. Here's what this settlement means for borrowers. Okay, so there are more than 7 million borrowers enrolled in the plan and will be required to choose a new repayment plan if the court approves the agreement. The Department of Education says it will conduct direct outreach and provide guidance in the coming months. For now, borrowers remain in the same administrative forbearance unless they have already opted into another plan. Interest began accruing in August, but payments are not required. Borrowers can already apply for alternative income-driven repayment plans right now, including income-based repayment, IBR, income contingent repayment, ICR, or even pay-as-you-earn, though PAYE, and ICR are both kind of phasing out as part of the OBBBA. That law, passed earlier this year, also created a new plan. Everybody should probably do this as the Repayment Assistance Plan, or RAP, which is scheduled for release by July 2026. You have options. Next steps for the Department of Education. Even with the settlement, the end of the SAVE forbearance is not immediate. The agreement requires that the department initiate a full negotiated rulemaking process to repeal the SAVE rule and consider the future of pay and the original ICR. The department emphasized that it has not prejudged the outcome, though the policy direction is heavily constrained by statute and the terms of the settlement. Until the process concludes, borrowers occupy an uncertain space. The plan legally cannot continue, but the actual plan to remove the borrowers from the plan is waiting on the legislative process. So our estimated SAVE timeline remains until we get further information. If you want to find our estimated timeline, you can see it at thecollegeinvestor.com. There's an article you can link to right inside this article. So the settlement also includes an unusual transparency requirement. Check this out. If the department plans to cancel more than $10 billion in student loan debt in any given month over the next decade, it must notify the Missouri Attorney General's office at least 30 days in advance. Interesting. So here's what borrowers should know if you're in this predicament. For households trying to plan ahead, the most immediate step is to assess repayment options using the department's loan simulator tool. Again, find that inside this article at thecollegeinvestor.com. However, it's important to note that as of this writing and podcast, the loan simulator is not up to date with the latest IBR calculations, and it doesn't have RAP yet. Just keep that in mind. The IBR calculation is supposed to be updated this month, which is December 2025. However, there's no timeline on an official RAP calculator, but the College Investor RAP calculator is available. We have one. We made one. Borrowers should also watch for outreach from their loan servicers and the Federal Student Aid Office as well. This requires that contact information is updated so that if you haven't checked your loans in like a year or so, go ahead and log in and ensure your address and email are correct. For those who budgeted around SAVE's lower payments, transitioning to other plans may increase your monthly costs. Lower-income borrowers who qualified for $0 payments, which never made sense to me. If it's $0, don't call it a payment. Anyway, under SAVE may still access those terms under certain IDR plans, but outcomes will kind of vary with that. Borrowers pursuing PSLF2, you should prioritize switching to an eligible repayment plan to avoid delaying your qualifying months. While the end of SAVE adds a little bit of uncertainty here, it also brings long-awaited clarity after more than a year of pauses, injunctions, and conflicting guidance. With the settlement now before the court, borrowers can expect more formal deadlines in the coming months. That is our show for today. I hope it was helpful to you. I know there were some confusing parts, but if you just go right inside this article at thecollegeinvestor.com, there are tons of links and resources, so it'll all make sense to you. Thanks so much for stopping by today, and we'll talk to you again real soon.